talk on how the ICO approaches a cyber investigation. My name is Tom Wilkinson, and I'm one of the principal cyber specialists here at the ICO who work in the investigations team. There's a lot to cram into this talk, so let's dive right into our objectives for this session. During this session, we're aiming to achieve the following. Consider the factors that help determine if an incident becomes an investigation. Understand how the ICO will communicate with an organisation that is under investigation. Explore how an investigation is approached. Develop an awareness of what the ICO may request from an organisation under investigation. And finally, know about the potential regulatory options we have at our disposal. For those who have never had direct communication with the ICO, it is worth setting out our process of communicating to data controllers and processors. Article 31 of the UK GDPR outlines that a data controller or processor will, where applicable, cooperate on request of the supervisory authority in the performance of its tasks. It is also important to say at this stage that not all reported personal data breaches and incidents will become investigations. Firstly, most of our correspondence will be via inquiries. These will be formed into one or more rounds of correspondence between the ICO and the controller or processor. These inquiries form the basis of our information and evidence gathering. You will always be given a clear deadline for when we expect these inquiries to be returned to us. Section 131 of the Data Protection Act of 2018 provides a permissive gateway for the ICO to request information from organisations as part of discharging the Commissioner's functions. Secondly, and less likely to occur, are conference calls with members of the investigations team. As information and evidence gathering needs to be formally recorded, we would generally reserve conference calls for any advice we are offering in the early phase of incident response and to clarify any questions from the inquiries. Occasionally, we need to issue an information notice. This is a formal request under section 142 of the DPA for a data controller, processor, or an individual to provide the ICO with information within a specified time frame to assist us with our investigations. We will issue an information notice when we consider it necessary to do so. In some circumstances, it may be a criminal offence to provide a response which is false. We will serve an information notice at our discretion. We will consider what action is appropriate and proportionate, including the risk of harm to individuals or the level of intrusion into their privacy potentially posed by the events or data processing under investigation, the utility of requiring a formal response within a defined time period, the utility of testing responses by the fact that it is an offence to deliberately or recklessly make a false statement in a material respect in response, and finally the public interest in the response. It is well beyond the scope of this presentation to cover some of the finer points around information notices. However, further information is available on the ICO website under the Regulatory Action Policy. However, it is also worth stating that this framework provides regulatory certainty about how we look at issues, engage with organisations, and make decisions in our work. So, in terms of what happens during investigation, here are the nuts and bolts. Our first priority with any incident is to ensure that data subjects are protected and ensure any risks posed to data subjects are mitigated as soon as possible. We should know the impacted categories of personal data and number of data subjects from initial triage. Here we look in more detail at the organisation's post-incident steps. If we consider recital 87 of the UK GDPR for a moment, which states it should be ascertained whether all appropriate technological protection and organisational measures have been implemented to establish immediately whether a personal data breach has taken place and to inform promptly the supervisory authority and the data subject. This places a high bar for what is expected, and therefore inquiries will focus on: was data exfiltrated? This comes under Article 32(1)(b) with reference to the confidentiality of personal data. Whether there has been an impact on other organisations, particularly in situations where a supply chain might be impacted or there is a data processor to multiple data controllers. Have forensic reports been produced to understand what happened? Has a risk assessment been undertaken for data subject notifications? This directly links to Article 34 of the UK GDPR and how data subjects will be notified if the breach is likely to result in a high risk to the rights and freedoms of natural persons. Then we move on to initial access. Once we are satisfied that data subjects have been protected from risks arising from the incident, our investigation into how the incident occurred begins. Evidence gathering from this stage focused on evaluating the organisation's Article 5.1f, 32 and 28 compliance where relevant. Article 5.1f is the security principle, Article 32 is the security of processing, and Article 28 outlines the obligations of a data processor. We will likely make frequent reference to various guidance, standards and frameworks in our work. This can include, but is not limited to, the MITRE ATT&CK framework, NCSC guidance, the Centre for Security Controls, ISO 27001 and Cyber Essentials. This is to ensure we are all working from the same common language and terminology. For instance, for those unfamiliar with the MITRE ATT&CK framework, for example, it's a knowledge base of methods that threat actors use against enterprise systems, cloud apps, mobile devices, and industrial control systems. It's a guideline for classifying and describing cyber attacks and intrusions. Like the ICO, it's vendor neutral in approach and widely used across the cybersecurity industry. The sorts of inquiries we would look to establish at this stage: how the threat actor initially accessed the network, so the attack vector; if the threat actor exploited any known vulnerabilities; if so, what are these, making specific reference to the common vulnerabilities and exposures referencing system or the CVE referencing system; evidence available to determine attack vector; and any known information relating to reconnaissance or resource development pre-incident. Then we move on to malicious activity. So using the provided evidence regarding a threat actor's initial access, we then further our understanding of the actions taken once access was granted. This stage often requires multiple rounds of inquiries to fully investigate the incident details. The sort of questions we would be looking to ask: external tools used by the attacker, e.g. Mimikatz; internal tools used by the attacker, for instance PowerShell; compromised third-party software; how privilege escalation occurred; how credentials were compromised; how lateral movement occurred; and how data may have been exfiltrated. Then we consider the technical controls. So with an understanding of how the incident occurred, both in terms of initial access and actions taken once access was gained by the threat actor, we can evaluate the security measures the organisation had in place. It's important to note here again that the ICO remain vendor neutral. We don't pretend to know the intricacies of a network as well as the organisation. However, we are looking to evaluate the effectiveness of controls in place against Article 32 and giving consideration to the state of the art. For instance, we will look to establish measures in place to protect compromised systems, use of standard security measures, for instance, multi-factor authentication; access control, how the threat actor evaded or bypassed security measures; login and monitoring; encryption and pseudo-anonymization of personal data; heightened security of special category data; and following the principle of least privilege. Finally, we consider organisational measures. Article 5.1f, 32 and 28 require that appropriate organisational measures are in place in addition to technical security measures to protect personal data. We will investigate organisational measures relevant to the incident. It is important for the ICO, as a regulator, not to focus only on what went wrong when an incident occurs. We also consider what an organisation did correctly, both technically and organisationally. For instance, but this is very much not limited to, incident response policies, backup policies, access control, logging, monitoring procedures, least privilege policies, third-party or processor due diligence and contracts, and things like staff training. Lastly, we're going to take a brief look at the documenting of evidence and decision-making. There could be a whole separate talk on this area, so I think it's important to narrow the focus to just one or two key points. Firstly, any responses to inquiries submitting during the investigation can be used as part of our evidence gathering and decision-making process. Broadly speaking, there are most commonly three outcomes to an investigation. The first of those is providing written advice to an organisation based on the findings of an investigation. For instance, it may be deemed that the infringements under the UK GDPR do not require a stricter regulatory outcome. However, there are certain technical or organisation issues that the ICO would like to see addressed. For example, an organisation may only have a partially implemented policy or procedure that would have helped them contain and recover from the incident with greater efficiency. It would be in these situations where we may make a recommendation accordingly. We may also issue a reprimand for infringements of relevant data protection legislation. For examples of these documents, it would be worth looking at the ICO website under Action We've Taken to understand the contents and focus. However, broadly speaking, a public reprimand will set out where the organisation has failed to meet its obligations under UK GDPR and the steps they should now take to address the issues. The third outcome is administering fines by way of penalty notices in the circumstances set out in section 155 of the DPA. Similar to a reprimand, these documents are available on the ICO website for organisations to see. We also have extensive information on our fining guidance, so you can read the process that underpins this particular outcome. Obviously, a monetary penalty is a significant step by the ICO, and, like a reprimand, there are multiple internal processes that we go through before issuing such an outcome to an organisation. A fourth and final outcome may be an enforcement notice. This may be combined with other actions already discussed on this slide. However, in isolation, it is a legal order issued by the ICO to an organisation where data protection law has been breached. It requires an organisation to take specified steps and sets a deadline by when this should be reached. Enforcement notices are much rarer than the other three outcomes discussed in this aspect of the presentation. And that's it. On behalf of the Cyber Investigations team here at the ICO, I want to thank you for watching our presentation.